So I'll just begin. Good evening to all participants, respective panelist, moderator, and the member of ADR community. On behalf of IIDRC, it is my pleasure to welcome you to today's webinar on ADR in IP and media, licensing, royalties, content conflicts, and AI created material. Before proceeding further, I would like to briefly introduce IIDRC. IIDRC functions as a neutral institution providing structured arbitration and mediation services. It has its academic and training wing, IIDRC Edge, which conducts workshop, courses, and webinar. We have launched ADR Across Industries Knowledge Series, and today marks the sixth session of this series. This series aims to foster meaningful dialogue, share practical insights, and promote leadership in emerging areas of dispute resolution. Today's topic is particularly relevant in the rapidly evolving landscape of intellectual property and media. With the rise of digital platform, content licensing, streaming services, influencers ecosystem, and AI generated work, dispute related to royalties, ownership, infringement, contractual rights, and creative control have become increasingly complex. These disputes often require industry sensitive confidential, and efficient resolution mechanism. In this context, alternative dispute resolution, particularly arbitration and mediation, play a vital role in resolving IP and media disputes, while preserving commercial relationship and protecting creative interests and ensuring business continuity. We are honored to have with us an exceptional panel of distinguished speakers and practitioners who bring deep expertise and experience in intellectual property and media related disputes. It is my pleasure to introduce our moderator for today's session, Dr. Shivani Lahoti. Dr. Shivani Lahoti is a legal academic specializing in intellectual property law. She was awarded her PhD law in March 2026 for her thesis titled An Analysis of the interface between patent and competition law in the Indian pharmaceutical sector. Before pursuing doctoral research as well as a full-time PhD scholar, she taught as an assistant professor of law at Amity Law School, Delhi, for over 3 years. She holds an LLM in intellectual property rights from National Law University, Jodhpur, and brings valuable academic insights and research expertise in the field of intellectual property and emerging legal issues. We are delighted to have her to moderate today's session on ADR in IP and media, licensing, royalties, content, conflict, and AI created materials. Without further ado, I now invite Miss Shivani Lahoti to take this session forward. Thank you, and I wish everyone an insightful and engaging webinar.
Good evening, everyone. It is a pleasure to welcome you all to this session on ADR and IP and media, licensing, royalties, content conflicts, and AI created material. I would like to begin by sharing this quote by Ms. Noyana Roy, a well-regarded media lawyer in India. It goes something like this. It says that if data is the new oil, then IP is the new gold. And if IP is the new gold, then technology mines that gold. The theme of today's discussion is both timely and practically significant. The IP and media sectors today operate at the intersection of creativity, technology, commerce, and reputation. Films, music, digital content, publishing, advertising, software, brands, performances, online platforms, and creator-led businesses all depend heavily on intellectual property rights. At the same time, disputes in this space often arise quickly and can have immediate commercial consequences. With the rapid growth of digital platforms and generative AI, issues have become even more complex than before. This is where alternative dispute resolution becomes especially relevant. Traditional litigation remains important, particularly where urgent injunctions, takedown directions, statutory remedies, or rights against the public at large are involved. However, many IP and media disputes arise from contracts, commercial relationships, and continuing collaborations. In such cases, arbitration, mediation, and negotiated settlements can offer confidentiality, speed, sector specific expertise, and commercially workable outcomes. This is particularly valuable where parties want to preserve ongoing relationships. At the same time, ADR and IP in media is not without challenges. Questions of arbitrability, urgent interim relief, multi party contracts, online infringement, platform involvement, and the role of courts continue to require careful legal handling. The Indian context is especially important because the law is developing through a combination of statutory frameworks, judicial intervention, and changing commercial practice. Today's discussion will therefore focus on how ADR can respond to the realities of IP and media disputes in India. We will examine licensing and royalty conflicts, online and platform based infringement, content ownership disputes, AI created and AI assisted material, personality rights, and the practical drafting of dispute resolution clauses. We are fortunate to have with us a very distinguished panel of speakers who bring expertise from dispute resolution, intellectual property litigation, commercial disputes, technology law, and regulatory practice. I look forward to an engaging and practice oriented discussion. It is my great privilege now to begin today's webinar with our first distinguished speaker, Mr. Zeeshan Khan. Mr. Khan is a partner at Luthra and Luthra offices, New Delhi. He has extensive practice in intellectual property practice. His work spans IP litigation and enforcement before courts and law enforcement agencies, trademark, copyright and design prosecution, customs registration and enforcement and domain name disputes before WIPO and NIXI. He has advised clients across several sectors, including FMCG, automobiles, oil and gas, retail, fashion, sports, and many more. He regularly appears before various high courts in the trademarks registry and has several reported judgments to his credit. Mr. Khan, I now invite you to share your opening remarks.
Thank you, Dr. Lahoti, for that kind introduction. Thank you, IIDRC, for organizing this and giving us the opportunity of expressing our views on this topic. This is actually a topic which is very close to my heart. I've been practicing IP for almost 18, 19 years now. But alternate dispute resolution in IP has never been talked as much as now this has been. And I think this is the right time that we start exploring alternate dispute resolutions as far as IP disputes are concerned. We all know the problem with litigation in India, be it civil or criminal. In certain cases, the procedure itself gets becomes punishment because of the delay involved, the pendency in the court. You don't get proper dates. Interim orders usually take years to for obtaining the interim orders. It takes years, and so forth and so on. In fact, in certain jurisdictions, filing an IP case and explaining the dispute takes a lot of task because we do not have IP specific judges in every district and every high court in India. Thanks to the Tribunal Reforms Act, there are certain high courts who have now created IP specialized courts. So there are IPD courts now in 3 or 4 major metropolitan high courts. But apart from those IP specialized judges, IP litigation going before the normal judges who probably have never practiced or never heard and decided IP disputes, it is actually a big problem for the IP owners, especially in India. So ADR actually comprises of majorly 3 points: negotiation, mediation, and arbitration. It is a critical mechanism for IP and media sectors. ADR offers specialized, confidential, and cost-effective resolution of the IP disputes, be it licensing, royalty dispute, accounting disputes, SCP disputes, patent disputes, and in today's scenario, copyright and IP disputes. Sorry, copyright and AI disputes. Now, usually the landscape of IP is bifurcated into, four highly relevant areas, which are licensing and royalty disputes, which usually happens in cases of trademark and copyright matters. Content conflict, usually with respect to unauthorized online content, platforms, copyright filtering and takedown notices, AI created material and IP. Now, when I say AI, there are twofold of IP disputes that may arise. Though this is like still at a very nuanced stage in India, it is at a developing stage. We still do not have a clear-cut judgment by any of the courts with respect to AI infringement. As far as AI is concerned, there are certain cases we all know which are pending before the Delhi High Court, and we are all eagerly awaiting final judgments in those cases, so that we will probably have a clarity as to how does the courts are reacting to these disputes. So AI created material and IP dispute would probably involve first an input data, wherein the AI model, which is trained on vast and proprietary data, which is probably available in the public domain, but maybe a proprietary data of someone. We all are seeing the open AI case, which is pending before the Delhi High Court and waiting for its final judgment. And second would be the output data. Output data, when I say, let's say someone has used an AI app and created a content, let's say a photograph. So who's going to be the actual copyright owner? Whether the person who has used the app itself, or the creator who actually created that app. This is something that we are all debating and deliberating upon as of now. There is one case which has been referred by the Delhi High Court to the Copyright Board. And we are all expecting that a final judgment from the Copyright Board probably would be passed by the end of this month, so that we'll have a clarity on this. And then the last leg of ADR and IP disputes, and a very important one, is the WIPO. So WIPO actually is the organization that handles cross-border disputes which are spanning in multiple jurisdictions. And why should one opt for WIPO? That's because WIPO has tailored rules. They have expert mediators and arbitrators who are trained in handling IP matters, who have been practicing IP. And there is a special mechanism to protect the trade secret and the confidential information. So I was actually handling one of the matters for one of our clients, and the dispute involved multiple jurisdictions: India, Singapore, Malaysia, US, and one more country. Both the parties were at loggerhead in all these countries. Cross suits were filed. Trademark applications of each other were being opposed by the respective trademark offices in these countries. And then ultimately, one of the parties suggested that why don't we sit together and try and mediate this? And then come the importance of WIPO, because in such scenarios, various cross-border disputes are being involved, where the parties are at loggerhead in many jurisdictions, it is always suggested that one should opt for WIPO mediation, because WIPO usually handles cross-border IP disputes. It is a specialized IP mediation and arbitration center. And then comes the domain name disputes. We all know there is a mandatory provision to opt. There is a mandatory provision that all domain name disputes which are being filed either before the NICSI, which is the Domain Name Registry of India, or the WIPO, which handles international domain name disputes, everything goes before before the mandatory arbitration procedure. The pleadings filed by the parties and the evidence filed along with it would be placed before an arbitrator appointed by either the WIPO or the NICSI. So these are the relevant forums which are these days handling ADR and IP disputes. We will discuss about all these forums and the nuances of how they handle in this session going forward. Thank you.
Thank you, sir. With that, we now move on to our next distinguished speaker who will further enrich today's discussion, Ms. Faranaaz G. Karbhari. She's a seasoned litigator and arbitrator with over 2 decades of experience in corporate commercial litigation, arbitration, mediation, and taxation laws. She has represented clients before the High Courts, Supreme Court, CESTAT, and various tribunals, and is frequently appointed as an arbitrator in complex commercial disputes. Prior to founding Alpha Chambers, Advocates and Solicitors, she worked with Crawford Bailey and Company for over 14 years and later served as AVP litigation at Vodafone. With that, ma'am, we invite you to offer your opening remarks.
Hello. Thank you, Dr. Lahoti, and of course the IIDRC for having us here this evening. And I will only try and supplement on what my colleague Zeeshan has already elaborated. Since he has mainly gone on the software aspects of it, I will try and address the actual practical working of the ADR and the commercials behind it. The point is that we all know that ADR is the in thing, is the go-to thing. I am an impaneled arbitrator as well as a mediator. I've gone through my 40 hours of training for at least 3 certification courses. And I have barely seen a mediation in IPR unless and until the parties actually wish to preserve their relationship, because it has to be by consent, of course. So let me address mediation first. It's a very tricky situation because, of course, it has to be by the consent of all the parties, and there has to be an intent to settle. And of course, all the parties have to be known to each other for that purpose. Coming on to the other aspect of the ADR, which is arbitration. Again, the question is interim relief, which is very essential for us because of the commercials involved, because of the pace at which today digital invasion takes place. Copyrights are violated with ease. Live streaming of matches are shown through mirror websites. All these need immediate prompt action. And how does one go about it? For that, one needs to go back to the contractual efficacy of an agreement. That is, of course, where the parties are known and where the OTT platforms are bound by those agreements to identify where your content has been infringed. We have something in India which is taking a lot of prominence in the last couple of years, which is known as the John Doe orders in IPR. Now, John Doe orders, what are they? John Doe orders are orders against unknown people. So when your content or when your copyright is infringed, when your trademark is infringed by unknown people. Of course, the immediate interim order is against those unknown people, sought against those unknown people. And then once the trial starts, of course, there is an investigation and there is the whole plethora of process that takes place in a normal thing. But yes, if ADR is to be considered, then one needs to be very careful about the fact that it has to be an institutional arbitration. Institutional arbitrations are empowered to take cognizance of an emergency arbitration and secure the rights of the person who is the owner of the copyright or trademark, and make sure that the infringement is stopped, there is no commercial loss that takes place, or a status quo order is then given. So when I say institutional arbitration, I normally mean international arbitration courts like the ICC, SIAC, etc., that are empowered to do that. In India, unfortunately, we have a very robust court system, which does provide us immediate relief. But as my colleague Zeeshan said, it is a matter of concern that we can only approach certain courts. So we all have seen a spate of protection of personality right judgments that have come in from the Delhi High Court. There have been hardly one or two from the Bombay High Court. If you ask in the fraternity, since the copyright board and everything is Delhi based, the Delhi courts are better equipped to handle these kind of matters and very prompt in listing and disposing of the matters. Because that also depends on the fact as to the content of the IPR, understanding of the IPR, and the commercial losses that are going to be suffered. The latest one is, of course, the 29th of May judgment of the Delhi High Court, where Himalaya was protected on their Live 52 trademark against somebody who was infringing and had a similar green and white bottle with a Live 22 mark. So that's the latest case that I can say. And it just, if you see the timelines of these matters, where from the time that they have been filed to the time of disposal, the timeline is pretty short, and that has to be the case. Again, the latest, again, the issue was about the broadcasting rights of Zee on the FIFA, which is the next big thing that is happening on broadcasting surface. And there were already mirrored websites which were claiming to also show these live. And the Zee actually got an order against them, against these rogue websites. Again, the concept is unknown rogue websites. So yes, you take down the domain name and you say that, okay, these are the websites that are claiming to be showing it. But by the time you actually track them down, they would be invisible or non-locatable, and they would have found another platform, thanks to VPN and thanks to all the technological, the rigmarole that is there. So prima facie, as somebody who has practiced for 25 years, I still believe that in India, the courts are the go-to for an interim order, immediate interim order. Arbitration, you need an arbitration agreement for it, a known arbitration clause for it. By the time you end up appointing an arbitrator, your boat has sailed. So yes, Section 9 of the Arbitration Act enables you to actually go to court before the appointment of the arbitral tribunal in order to secure your rights. So that's that. International forums, if your agreement provides you with it, like the SIAC, the ICC. In fact, there is a very strange phenomena that I have noted while I was actually reading up for this. And that is that apart from the ICC and the SIAC, there is a Scottish Centre of Arbitration, which has the lowest, or rather the fastest disposal that is there. Now, apparently, they say that the appointment of an arbitrator takes place within 24 hours of invoking an emergency arbitration, and the award is supposed to be disposed of in a span of 4 to 5 working days. Whereas ICC and SIAC, all of them go beyond that 5-day or a week routine. So that's more or less my take on the subject, where it is IPR related. I actually like IPR because interim relief is very fast to get in that. So the disposal of matters as professionals, Zeeshan is laughing, of course, that we don't have to, kind of wait till the disposal of the matter. Let me put it that way. That's all from my end, at least, for now. And that is a very technical and a practical approach where courts and ADR is concerned.
Thank you so much, ma'am, for these insights. With this, we now invite our next speaker, Mr. Aniket Aggarwal, to take the session forward. Mr. Aggarwal is a principal associate at Jyoti Sagar Associates, specializing in complex commercial, corporate, and insolvency disputes. He regularly advises and represents clients across fora, including before domestic and international arbitral tribunals, the Supreme Court of India, and the High Courts and the National Company Law Tribunals of various states. He has a wide-ranging experience in practice, including clients from energy, real estate and infrastructure, media and telecommunication, banking and financial services, securities, retails and services, and knowledge-based industrial sectors. Sir, I now invite you to share your opening remarks.
Good evening, everyone. And to Dr. Lahoti, thank you for the kind introduction. To IIDRC, thank you for having us. And to all the panelists, thank you for joining us this Saturday evening. And as a principal associate at JSA, I spent most of my professional life dealing with disputes arising from contracts that seemed perfectly sensible when they were drafted and executed, and completely inadequate when they were ultimately tested. And in many ways, that is what captures what's happening across the IP and media industry today. For decades, IP disputes followed very familiar patterns. A copyright owner licensed content, a broadcaster distributed it, a platform monetized it. It was fairly simple. And if something went wrong, the dispute revolved around ownership, infringement, royalties. Today, however, the underlying assumptions themselves are changing. AI is generating content which is being curated by pre-programmed algorithms, and such content is distributed instantly across the globe by platforms. So the parties involved in creating, exploiting, and monetizing IP are no longer just two or three human actors, but entire technological ecosystems. Take a modern streaming release, for example. A single piece of music would involve a creator, a production house, a music label, a platform, advertisers, technology vendors, as well as AI tools. So when something goes wrong, the first question becomes which of the six contracts to actually invoke. Because of such developments, many of the disputes that we encounter today are not really complex or larger versions of the disputes that we saw earlier, but they are actually fundamentally different kinds of disputes. The traditional question in IP law was who owns the work? But now the questions have changed. The questions now are who contributed to the work, who controlled the process, who benefited from the output, and perhaps most importantly for this session, who bears the risk when technology behaves in a way that nobody anticipated. What strikes me is that the legal system is being asked to answer questions that are evolving faster than jurisprudence itself, and that is something Mr. Khan also mentioned with the cases which are pending before the Delhi High Court. So really what happens is by the time an issue is litigated and decided, technology has already developed and already moved on to a newer question. And that is simply the reality of the pace of innovation today. And because of all these reasons, I feel ADR is becoming an increasingly important factor in the IP and media space, and not merely because of speed, because speed is only part of the story. ADR's real value, I feel, lies in flexibility. It allows parties to bring together expertise from commercial, legal, and technical domains in a way that traditional dispute resolution still struggles with. And as Faranaaz ma'am also mentioned, it allows parties to reach commercially workable solutions even when the legal framework is yet to adapt. However, again, with the caveat that, say, for example, mediation, parties have to agree to go for mediation to be able to reach a solution. And perhaps most importantly, ADR allows industries to develop practical solutions and practical norms while the law is still yet to catch up. The other reason this discussion matters is that many modern IP disputes arise between parties who have to continue working together long after the dispute ends. And that is something, Dr. Lahoti, you mentioned. Say for a streaming platform and a music label, they have to continue working together. A technology company and a content owner, a creator and a distributor, they can't break their trust down in severe relationships and walk their separate ways. So preserving relationships truly is instrumental, as an entity which is an opponent today might be a commercial partner for tomorrow's business. And that reality is something that has to influence how we actually think about dispute resolution. So the challenge is not simply how to resolve disputes efficiently, but how to actually manage disagreements without destroying the value. So, as we proceed with today's discussion, I would urge focus and invite thought not only on legal outcomes, but also on the very architecture and design of dispute resolution, because increasingly effective resolution is not a dispute which a party wins, but one that never escalates in the first place. And ADR, I feel, has the potential to act as a smoke detector rather than a fire extinguisher. And that's all from me in the opening. Thank you.
Thank you, sir. As we carry forward this conversation forward, it gives me great pleasure to introduce our next speaker for the day, Ms. Nishtha Sharma. Ms. Sharma is the Associate General Counsel at Schrödinger India Private Limited, subsidiary of Schrödinger and Corporation New York, based in Hyderabad. She leads the end-to-end legal functions, POSH framework, and legal ops for India GCC and sales offices, and commercial sales and procurement legal functions for Asia Pacific regions. Welcome, ma'am. The floor is all yours.
Thank you, Dr. Shivani, and thank you, IIDRC, for organizing this very insightful conversation, which is pretty much the need of the hour right now. And thank you for the other panelists for sharing your insights. Where will I, add value to this conversation would be, of course, I see all three of you are on the contentious side of the practice, and you would, help all of us understand how things manifest when the disputes happen. I would probably, help and discuss scenarios where we at company try to, like Ankit mentioned, we try to, manage the situation in a way that it never actually escalates into a dispute when it comes to these AI or the technology or wherever AI or IP is involved, right? And I have around 13 years of experience, and for me, it's almost like an opposite, right? I started as a legal practitioner. I was practicing in court. I have seen these disputes happening, managing arbitration, and then I have moved in-house. So I've seen how things happen once the dispute goes, and then I have gone back and then tried to see how companies mitigate it, right? So that's where I will try to cover the 360 cycle of it. And what I'd like to say is, of course, when we talk about the dispute resolution mechanism, right? When I was working in arbitration, this was like 12 years back, IP space in terms of arbitration was not so evolved. Why? Because, we were still debating on the fact that do we need an institutional arbitration or do we need like an ad hoc arbitration? And let's say if we need an institutional arbitration, those institutional arbitration centers would have panel of arbitrators. Now they would be subject matter experts. So when we look at 13 years back, 12 years back, those experts were not really IP experts, right? So if two companies are going forward and saying that we have an IP dispute, would that arbitrator understand that concept? It was still debatable, right? And then again, should it be like a regional arbitration? Should it be between two India parties? They are going and doing an ad hoc arbitration versus one India and one global, and they're going to SEAC or ICC, etc., and then hiring arbitrators, right? So the concern that we saw at that point in time was, and this is coming from one of the matters that I handled, this was to do with Gift City, which is a very prominent industrial area in Gujarat, right? And the project was, it turned out to be beautiful, but one of the dispute that continued for good 7-8 years, even after the launch of the project, was who owns the blueprint of the design of Gift City, right? And how it came into picture, because there were several vendors who were involved in it. Of course, there is PSU SPV that was set up for this entire purpose. But there were certain technological platforms that were involved in creating the blueprint. Once the blueprint was done, the designing and fabrication was done by another vendor. So now when everything happened and when it was about the royalty and the commission distribution, the dispute that came before the both sides of the party was that who owns the blueprint? Is it the one who created the design of that entire, gift city? Or is it the one who designed the basic blueprint, the pillars and the structures of the gift city? And this was a 6,000 crore matter that went on for 6 to 7 years. And eventually it got resolved in a way where they said that we are going to share a 50-50 revenue of this entire process, because blueprint, you cannot separate the blueprint from the design, etc. So it was all about, I would say 50% was about what the law had evolved at that point in time. And again, one of the aspect at that point in time when we struggled was the interim injunction. Interim injunction for these matters were not easily available at that point in time. So then they said that we are going to come to a mutual compromise and we'll see where do we meet at the table. So eventually it turned out to be like a contract commercial negotiation where we say I want 80% and I want 30%, etc. And eventually the parties kind of agreed for 50-50. So that's where I was at 10 years ago. And now I am with a product company. And most of these product companies have AI, which cannot be separated, right? So how do they really work? When I say product company, these would be SaaS-based platforms, any website that you're using, any services. It will be a software, but it's actually a service that is recognized. So different aspects comes into play because your product, your company is going to be taxed as well, right? So it's a SaaS-based service, so the taxation and revenue recognition would be different. And when they calculate, they will also see what sort of IP is being created when these companies are creating some software or products. So it all starts at that level. How do you create a product? How do you decide the name of the product? Does it name conflict with something else which is already existing in the market and which already has like a sufficient market value and a revenue to it? Because again, the whole dispute about who has, who holds a longer usage right comes into picture. Then it goes to advertising it, marketing it, putting it before the investors pitch and say that this is the product or this is the platform we are going to put. This is where it has, let's say, 30% of AI component, where a new concept, which I mean, it's not a new concept, but it's more bubbling now, is the agentic AI aspect, in the sense that you have a platform and you would see those chat windows popping. Can I help you? Customer care, etc. So those are agentic AI. It's not like somebody, like a person is dealing with you on those chat windows. It's a machine who's responding to you. And how does that work? You put the metadatas. Why? Because you anticipate that these are the questions that the customer is going to ask me. So those metadatas are pre-filled in those agentic AIs, and then the responses are generated. So then in those situations, what companies such as ours we do is we say that you can refer to agentic AI chatbot, but then when you go ahead and utilize that information, it is going to be at your own discretion and it's not going to come back to us, because it could be a business reason. You can go ahead and decide that, based on that information, I'm going to launch my product and I'm going to make 500 crores. And if you make 300 crores, you can't come back and say that the 200 crores were not earned because of the chatbot that responded to me, right? So these are some of the issues that we try and mitigate. And at the level when we decide the entire packaging, when we offer it to the customer, what sort of SLAs are established in that. And I think we'll be talking in detail about the different clauses that ensures that different parties who are involved in this entire process, like Aniket mentioned, in terms of there can be a service provider, there can be a licensee, there can be different components or different parts of the services which will combine together and become a package, right? So how do you really identify and distribute your rights and obligation between all these parties, so that when there is a dispute, you always know that you have to go back to one particular source instead of working around the fact that where should we go becomes in itself a dispute, right? So, and all of this, and how do we really bundle it with the arbitration clauses in the commercial agreements, is something that I would like to throw light on to all the audiences. So that would be all for now, and we'll see how the conversation goes.
Thank you, ma'am. I thank our speakers for their opening remarks, and now I look forward to engaging with the subject for today in greater depth. So I'll put forward my first question to Ms. Faranaaz. Ma'am, in IP and media disputes, parties often need urgent relief such as injunctions, takedown directions, or restraint against unauthorized use. In your view, how should parties decide whether to approach a court first or rely on arbitration or mediation under their contractual arrangement?
So, like I said, we have classification on where we go for what dispute. Now, if it is against the unknown people, if there is an infringement, a broadcasting infringement, a copyright infringement, if there is something urgent that needs to be done, then yes, the courts are the best. I still maintain that the courts are the best go-to for immediate action. And then if there is an arbitration clause, because by the time you actually follow, unless and until, I'm specifying that caveat, that unless and until it is a institutional arbitration, emergency arbitration is still a testing field in India. Under the Indian arbitration rules, let me put it that way. Under the Indian Arbitration Act, it's a testing field. If you are under the ICC rules, the SEAC rules, and in my introduction, I did mention that Stockholm Chamber of Commerce, the SEC rules, in fact, has the fastest mode of disposal of an emergency arbitration. But I don't think many of us are aware of it, or even use it because we are normally more SEAC inclined, ICC inclined, or LCI inclined. Now, all of these, I think even the ICC has a week's disposal, more than a week, 10 days disposal deadline. Aniket did mention that the speed normally is not something that is of concern. But yes, if it is a mediation, if the parties are consenting, again, all these need to be tick marked, and only then do you go in for mediation. So mediation has its limitations. Arbitration, do you have an arbitration clause? Are you bound by an arbitration clause? Can you see that there can be an emergency arbitration possible under the arbitration clause that is there prevailing in your contract? So all these things need to be addressed first. If it is a general arbitration clause without an emergency arbitration clause there in your contract, or if your arbitration clause is under the Indian Arbitration Act, the whole process of appointing an arbitral tribunal, or even before that, you will need to go to the court. And in effect, even if you go to court under Section 9, you will be able to get at least a status quo order to make sure that the infringement does not continue. What is it that we ask for normally in an IPR? So if it is somebody who's violating, like I mentioned, the Himalaya order, which was there just now, and it's the latest thing that has come out of the Delhi High Court, what was it that they were asking for? They just said that stop them from manufacturing, selling, and advertising. These are the three urgent reliefs that you need. Because they said the bottle is the same, it's the green cap, white bottle, the mark is the same. They are even. It's just that mine is live 50 and their product is live 22, whatever the difference that may be. But and an interim order was given. So when you are looking at the urgency, the commercial ramifications, because more of those goods that would have been distributed in the market, Himalaya would have suffered a loss to that extent, because there would have been a confusion between the two products. It was more of a passing off, let me put it that way, because they were trying to pass off. They have the broadcasting rights with them. We are still 1 week away from the FIFA starting, and there is already a controversy about certain websites claiming to broadcast the matches live. And these are pirated websites, these are VPN-based websites, these are websites that fly by night, and they claim that they will be mirroring the real time and showing the matches real time. Thankfully, it came to the notice and the restraining order was obtained even before the matches have started. So the loss that they would have suffered in real time has been prevented. So, I think time is of the essence in most of these issues, which is why, as a practitioner, I always believe that I need to find out the most time bound, efficacious remedy for that particular dispute. I mean, if it is and all parties are ad idem on it and they want to maintain their relationship and find a way out, then mediation, yes, because all of them have to be of the same mindset to maintain that relationship and carry on that working commercial relationship further. I hope I've answered your query.
Yes, ma'am. Thank you so much. The next question is, from an IP enforcement perspective, licensing disputes often begin as contractual disagreements, but may quickly turn into copyright or trademark infringement claims. How do you see this overlap playing out in India, and where does ADR fit into such disputes? I addressed this question to Mr. Zeeshan Khan. I would like him to share his views on this.
Look, Dr. Lahoti, all IP disputes these days are commercial disputes, and they are all governed by the Commercial Courts Act. There is a mandatory provision under the Commercial Courts Act, Section 12A, which says that all commercial disputes, before being filed before the courts in India, have to go through a mandatory pre-litigation procedure, Section 12A. So all IP disputes, by very nature and the definition of the Commercial Courts Act, are covered under the broad contour of the Commercial Courts Act. And therefore, by virtue of the provisions of Commercial Courts Act, every IP dispute that is going to the court, because of Section 12A, the parties are mandatorily have to go through pre-litigation mediation under Section 12A, which means that before filing the case in the court, you have to approach the mediation authority of the concerned court, file a petition there. The opposite side would be called. Both sides would be asked to sit across on a table with a mediator and try to resolve the matter before going to the court. If the matter does not get settled in the mediation, then probably the next course of action is to file the suit before the court. That's the normal procedure in all commercial suits, including IP. But as Faranaaz rightly pointed out, a lot of IP owners usually would not want to go through this lengthy procedure because of a lot of intricacies involved in IP disputes. Let's say what happens in cases of counterfeit products. Your client sales team has identified that there is a manufacturing unit, or there is a warehouse which has a large quantity of counterfeit products. They're manufacturing it, they're stocking it. In such cases, does it really make sense to go for pre-suit mediation? I mean, if I approach the mediation center sends them a notice that, look, you have to come and participate in the mediation. Before they come for the mediation, they will flood the market with the counterfeit products. And when you approach the court for an injunction and raid them, you will probably find nothing. So it all depends as to what is the nature of the dispute. Let me talk about online, content, copying the content in online advertisements. So there have been a lot of cases wherein parties use someone else's intellectual property in advertisements or disparaging advertisements. In such cases, does it really make sense to go for mediation? So it all depends on the kind of dispute that you're going for. So we all know the kind of impact advertisements have these days. If you're allowed them to be on air for 7 days, they would have done their job. And after that, even if the court, gives you an injunction, or if you're able to settle the matter in a mediation, probably the infringing content would have done its job, and the harm would have already been done. So, and that is why the Supreme Court has come up with the Yamini Malhotra judgment, which says that in certain cases wherein no urgent interim relief is sought, And if the court is satisfied that, yes, there is need for an urgent interim relief, the parties, the plaintiffs especially, can be given a special permission of directly approaching the court and do not go through the whole process of 12A, pre-suit litigation. So in such cases, we, as the owners of the as the lawyers of the intellectual property owners, the lawyers for the plaintiffs, we filed an application seeking exemption from the procedure of 12A. In that application, you have to explain to the court as to what is the urgency involved in the matter, by virtue of which you are seeking an exemption from 12A. Yamini Malhotra, the Supreme Court has clearly gave guidelines that in what all cases the parties can be exempted from going through the procedure of 12A. If you are able to satisfy the court that, yes, there is an urgent need to directly approach the court and to obtain the order on the first day of hearing, even without serving the defendant in certain cases, then definitely, yes, you can directly approach the court. And the courts have been entertaining such cases. The only problem is, yes, there are ifs and buts of all approaches. There have been certain cases wherein the plaintiffs, only with the intention of, not going to the mediation, probably in certain cases wherein no such urgency was involved, would have filed exemption from 12A applications. But it all depends on discretion of the judge as to whether such application has to be allowed or not. Even if, let's say, there is a party who may have directly approached the court with an application for exemption of 12A, but if the judge is not satisfied with the urgency involved, the judge can definitely at any point of time direct the plaintiff to go to the mediation center, try to mediate the matter, and then if the mediation is not successful, then probably come back to the court. So it all depends on the nuances of the dispute involved as to, I definitely support pre-suit litigations, mediations, and arbitrations. It is very cost effective, a win-win situation for both the parties. Obviously, it saves a lot of time. In fact, in a lot of my matters as well, wherein we have sent legal notices to the parties. And when the parties either do not respond or respond negatively, which means that they do not agree to the demands of my legal notice, in such cases, probably, we suggest the client to go through pre-suit mediation, because there are chances that even if the party may not agree to the requisitions of a legal notice, but if you ask them to come and sit with you on a table for a mediation in the presence of a trained mediator, there are chances that the matter gets settled. And the clients obviously would be happy with such an approach because it saves a lot of money as well. You don't have to file the entire court fee. It saves a lot of litigation fees. And obviously, time is of essence. So they would be able to better, concentrate on other aspects of their business rather than concentrating on the litigation. So yes, there are certain cases wherein we also, as lawyers, suggest our clients to go for pre-suit litigation mediation. But it all depends if, as I pointed out, if it pertains to a lead that you have got, that there is a certain warehouse in a particular area in Delhi which is which has like 1,000 pieces of counterfeit products. In that case, in my opinion, it does not make sense to go for pre-suit mediation or any sort of ADR, arbitration or mediation, because that this is a counterfeiter and he is not he's someone who's doing it with intention. He knows that what he's doing is wrong. And the moment he receives a notice from the court, he will probably flood the market, everything will vanish. He will come to the mediation and probably you will have nothing to prove. So in those cases, yes, we directly go to the court with an application seeking exemption from pre-suit mediation by explaining as to what is the urgency involved in the matter, satisfy the judge, and obtain an ex parte injunction order on the very first date of hearing. Along with an injunction, we also request the judge to appoint a local commissioner so that the local commissioner can visit the defendant's premises without giving an advance intimation, seize all those products, and then bring a report to the judge that works as an evidence. because majority of these people are either fly-by-night operators or they are very clever, working clandestinely, and that's why it all depends on what kind of dispute is involved, whether you should go for mediation, arbitration, or directly approach the court as far as IP matters are concerned. Thank you.
Thank you for answering the question so comprehensively, sir. My next question is addressed to Mr. Aniket Aggarwal. Many content and technology contracts now involve multiple layers: creators, platforms, production houses, advertisers, investors, and technology vendors. From a commercial disputes perspective, what are the most important drafting points in dispute resolution clauses for such multi-party IP and media arrangements? Mr. Aggarwal?
Yeah. So one consequence of what I mentioned earlier regarding the move from bilateral relationships to entire content ecosystems is that dispute resolution clauses have become more and more significant now. And what drafting changes have to be made to those clauses, probably an entire webinar can be conducted on that topic alone. But I'll limit myself to a few suggestions. The traditional approach to have one dispute resolution clause for the entire contract for each party, that is not sufficient. As Mr. Khan also pointed out, that will change depending on the nature of the dispute. And that is very real because a creator, a platform, an investor, a technology supplier, all of them have different expectations. So, what is crucial in my view is to completely understand how the business operates and how the contractual relationship is actually going to play out in real life. Because realizing that is important to be able to tailor the dispute resolution clause for a particular transaction. It's clear a creator in cases of say deep fakes or infringing content, a creator wants immediate takedown. What an investor wants is sort of a finality and enforceability. They are more concerned about the protection of the capital that they have infused. A technology supplier essentially more often than not is looking for a judge who actually understands the technical aspects, the code that has gone into the product. So my first suggestion is that we stop thinking about dispute resolution clauses as a single provision and start thinking them in terms of an architectural framework. So different disputes have to follow different tracks, and the dispute resolution clause in a contract ought to specifically provide for those different tracks. For example, urgent takedown disputes may go to emergency arbitration. But as Faranaaz ma'am pointed out, that is possible only when you know that who actually is responsible. If there are unknown parties involved, then definitely, then arbitration cannot be an option, and emergency interim relief before the court remains the only option. Royalty and accounting disputes, they may go to expert determination. Clauses can provide for a standing panel of neutrals and rolling annual windows for mediation where these can be reported and resolved on a regular basis instead of waiting for trust to erode and the volcano to erupt. Specific carve out should be made for, especially for ownership disputes for traditional litigation, because if that comes up and the dispute resolution clause does not provide for it specifically, then it's just a whole lot of time wasted just adjudicating arbitrability of the case. And that is not beneficial for any business. My second major suggestion is that joinder and consolidation provisions have to be specifically built in. They are no longer optional. Parties can no longer simply rely on Cox and Kings at the time of your Section 11 petition. Most significant media disputes today have multiple parties and overlapping responsibilities. You sue the platform, but the ad agency was the one who has uploaded the content. So, without effective joinder mechanisms, parties will simply spend time battling parallel proceedings over the same YouTube video. Dispute resolution clauses must therefore contain specific time-bound provisions for joinder of parties and consolidation of parallel proceedings. And that I believe will help in reflecting how the business actually operates and not merely how the contract is organized. So those are my 2 cents on this issue.
Thank you, sir. Thank you for answering the question. My next question is addressed to Ms. Nishtha Sharma. Ma'am, in your experience, negotiating commercial contracts across jurisdictions, which licensing clauses tend to become the biggest flashpoints during disputes, scope of use, exclusivity, sub-licensing, or termination rights?
Thank you so much for that question. Before I answer that question, I'll just add to what Aniket mentioned in terms of, what else can we do about the arbitrability so that, just for the sake of the conversation. And this is a very candid take on it based on whatever we have experienced so far. I think there should definitely be, there is one, but like a stringent code of conduct on the arbitrators as well, right? Because half of the time, even if, let's say, the provision says this is 5 days, this is 7 days, this is 15 days, it will get extended because of their conduct. Sometimes they're not available, sometimes they're available. When they're available, they come for the session, they want certain food. I'm sorry, I'm being very candid about it, but they would say, I want my lemon juice. And then the matter will not go on. And then we will spend the whole time in just arranging the lemon juice. Or if we are doing like an out of the city arbitration, then they would want to have their whole family members kind of join for the whole trip. So I'm just saying that there should be definitely some diktats for these arbitrators also, to suggest that you have to have a code of conduct very similar to what we have in the corporate, that when we are doing it, please stick to the timeline, please stick to the procedure, and all of these out of the bracket ancillary stuff should not be tolerated. It's just a pain point from companies, so I thought I'll add to that. This is one part of the reality. And okay, coming back to the question. So I would say, Dr. Shivani, that this is a 360, like how all the other panel members also said, that it completely depends on how you have crafted the entire agreement, how you have crafted the entire discussion between all of yourself. So it all starts at the level where, let's say, and I'm going to strictly speak from a company perspective, irrespective of the industry, whenever they are about to launch a business or a product or a service, they have to really think about the brand name, right? So it all starts at the level where they go and say that, hey, you know what, we want to launch this product and we want to launch it globally. So we would have to do a prior art search. We would also have to do like whether this name has been taken or is it similar to any existing industry or not. And then you also see that whether the name is matching with the purpose of your product, because you have to also make sure that the investors can see that cohesiveness. And all of this again requires an IP counsel to be there throughout the entire process. Now, once that is done, that's where you start establishing your SLAs. And SLAs are an important part of any agreement. So if I say that, this is the particular clause that we need to look at, no, it will be a cycle. Once you start opening the licensing clause, it will take you back to how the intellectual property has been defined, how the work product has been defined. So I'm just quickly going to give you that entire cycle when we decide all these situation. It will always start at an NDA level. Let's say if I say that I want to give my product to this particular company for them to see and figure out whether they want to buy it from me or get the license from me or not, we will do an NDA. Now, NDAs will also define those terminology saying that this is client's IP, this is my IP, this is pre-existing IP, this is the IP that may be created out of the collaboration. We are not exchanging anything unless and until there is a proper MSA, master service agreement, in picture. Now, let's say the NDA is sorted. Then comes the master service agreement. We redefine these terms in more detail because NDAs are always very short, 1-pager, 2-pager. Nobody wants to spend too much time on it. So they would always say that, okay, let's define our IP now properly. So that, let's say Schrödinger wants to define the IP. We say this is what IP means to us because we are into software business. So we'll try and put in all the caveats that covers our software, the modifications and the improvements. Now we will also see what the client is doing. Now the client is probably into drug discovery initiative. So we will define that this is what IP means to the client for this particular agreement. Then we will say that the parties have come here to decide and create XYZ work product. Now the work product is always works for hire. That concept is like we create it for the client and we give it back to the client. Say now at a certain time upon the payment of the fee, this entire work product belongs to you, right? But now, because that work product has been created by us, there is some sort of IP that goes from my company in that, which cannot be segregated. It will always be there every time the client uses that work product. So then we define that when you're using this particular work product, then your licensing and IP related clauses comes into picture. And these are specific clauses, 2-3 riders. They would say that this work product is given to the client upon payment on, let's say payment term is 60 days. I give the work product, you have to pay me upfront 60 days. And after that, the IP belongs to you. But the IP where I say that, this product has used the software that I, offer to the client. So all the improvements and the modifications that may have happened while we were dealing with the client's work product would always belong to us. Otherwise, the client can always say that, hey, you know what, you were working on my research, and because of that, your software got evolved. So that IP should come to us. That will never be the question. We will always segregate and say that this belongs to you. This is what belongs to us, but we are allowing you through sub-licensing and through certain, exclusive content, that while you use the work product, you have the license to use these attributes of the IP as well. Right. So that's one part of it where you really define the relationship. If there are royalties involved, let's say the client says that I'm going to make X product. Once this is launched in the commercial market, then this is the royalty that you will be getting. So you define that royalty sharing model also. 50-50, 30-20, what is the term around it? How many years do you have to continue to pay royalty, etc.? What would be the modality? Which account is it going to hit, etc.? When is the instance where party says that, we agreed for X amount of revenue, but it has doubled or tripled in a certain year. So then the royalty will also go up. So you define all those milestones in those royalty sharing sections. Then comes your indemnification, your limitation of liability, and your governing law clauses. Governing law is something, I think there's a second question to that, so we will probably cover there. But how you define all of these clauses will really determine how your indemnification and limitation of liability clause will be triggered. Because let's say there is a breach, let's say one of the parties said that I'm going to fulfill all the obligations, but there is a mishap that happened. Then in those cases, we will look at these clauses and then look at the indemnification. Is it like a 50-50 indemnification, or is it like, if this happens, you are going to indemnify me in certain regions? Now, those capping of regions also happen if you are talking about global companies. So let's say my IP is evolved out of US. And I tell my client that, how my IP behaves or what is permitted to my IP in US may not have the same approvals in APAC, right? Because the moment it goes to APAC, they have different IP laws. IP laws varies. It's not consistent at all. No matter how much we try to say it is consistent, it is not. So then in those situations, we would always try and cap it and say that, if there is an infringement of the IP, or let's say if you come back and say that I misrepresented and I said that this technology belongs to me, but it actually does not, and there is another party contesting the IP rights on it, then in those situations, I'm only going to indemnify in the US or in XYZ regions. So these are sort of considerations that the company takes in order to ensure that the cost is also controlled. And should there be any liability, that is also capped, because the very reason that we would give would be, we don't know how your IP is going to behave in a different region. We are not aware of it. We are not the legal experts. And in order for us to understand, we will have to incur certain costs in terms of hiring lawyers in that, in that particular region, etc. And then it will bring us to what we have agreed so far, and what is the model of dispute resolution that we have agreed. And then again, we will factor in a lot of other considerations. So these are some of the very important aspect when we talk about the commercial clauses in the agreements.
Thank you, Nishtha ma'am. Thank you for your insights. My next question is for Mr. Khan. Sir, in the media and entertainment industry, royalty disputes often arise from music licensing, publishing, film distribution, streaming rights, and performer-related claims. What are the most common causes of royalty disputes in practice, and can mediation, in your opinion, help resolve them more effectively than adversarial litigation?
Look, in certain cases, in these kind of cases, I would definitely advocate the parties to go for mediation, because In these kind of cases, usually there is no grave urgency which is involved. You probably may not need an injunction before the sunset in such cases. The dispute mainly revolves around the licensing agreement between the parties, or probably where the licensing clauses and the royalty terms have not been clearly defined between the parties. If defined, one of them would have faltered in complying with such clauses. Uh, and I believe that in licensing issues, all the IP owner would be asking about is the monetary consideration for the work that has been, that the party has been permitted to use. So if I talk, let me take the example of a music composer, probably who would have composed music. The ultimate purpose of him composing the music, generating the work, is to permit probably a producer, a director, or a music album to use that music and monetize the work. And the ultimate purpose of the owner of the copyright, which is the music composer in such cases, or let's say a performer in a cinematograph film, their entire purpose obviously is to permit a third party, someone who would have taken a license or a permission from them to use that work in their ultimate production, is to monetize the work and generate revenue out of it. So in such cases, I do not believe there is any grave urgency involved. And in such cases, definitely the parties should be encouraged to, explore the chances of mediation. And that is where, again, Section 12A, which is pre-litigation mediation, comes into picture. Because in these kind of cases, even if you would have approached the court asking for an exemption from mediation, the court may not be inclined to, entertain this exemption petition, and will probably ask you to go back to mediation, sit across the table, try and mediate the dispute. Yes, what may the court consider in such cases is if there is a third party right which may be created, or if the status quo has to be maintained, that urgent interim relief may be granted by the court. But there have been a lot of cases where even after grant of urgent interim relief on the first date of hearing, the courts have thereafter directed parties to go back to mediation and then try and mediate the matter, settle the dispute. So yes, in licensing disputes, broadcasting rights, wherein no such grave urgency involved, the courts also encourage, and as IP practitioners, we also suggest our respective clients that the better way is to follow the procedure given under Section 12A, try and sit with the opposite party with an open mind and see if we can mediate the matter before going to the court. Because if you're able to settle the matter in mediation, it is definitely a win-win situation for both of the sides. As I pointed out earlier, you're going to save a lot of money, you're going to save a lot of cost, time, energy, and resources, which probably the parties can use in the actual work that they're doing. So yes, in these cases, I would definitely suggest the parties to go for mediation than rather litigating these disputes directly in the court. Obviously, if parties are not able to come to a settlement during the mediation, then the only remedy left with them is to approach the court for protection of their intellectual properties. Thank you.
Thank you, sir. Thank you. Now, my next question is for Ms. Faranaaz Karbhari. Ma'am, in disputes involving digital content, the damage may be immediate because infringing content can spread rapidly online. How can ADR mechanisms be made effective in such cases where speed is critical and where platforms or intermediaries may also be involved? Faranaaz, ma'am.
So at the cost of being a little repetitive, I have always said that traditional arbitration was basically designed for conventional commercial disputes. Digital content disputes operate on an entirely different level with a different timeline. For example, a pirated movie or a leaked manuscript, uh, a deep fake that is generated that goes viral. Okay. Now, if you follow the conservative arbitration mode, you have a 30-day period for appointment of an arbitrator, assuming the other side agrees, etc., etc. The whole mechanism under 11 takes place. If not, then you go to court, have an arbitrator appointed. Of course, you have the liberty to go to Section 9 again. But I would much rather prefer to go to court first and then follow the arbitration process. I would not give the arbitration process a go by. Like all of us have said that that is for lasting relationships. So if there is a contract and if there is an ADR clause available where I can go, because that is the benchmark and that is the cornerstone of an arbitration. It has to be mutual. There has to be an arbitration clause, an arbitration agreement, as we call it, and that you have to show the urgency in a Section 9, which you can go for even before the initiation of an arbitration proceedings. If you are in an institutional arbitration, then of course the emergency arbitration is available to you, and the rapid speed at which orders are given. And we have the recent case laws in Amazon versus Future, etc., where they have said that that 17.2 allows for the execution of these foreign awards out here. So there is absolutely no doubt about the fact that there is an initiation that is there, and we are gradually moving towards adapting ADR where and which is both arbitration as well as mediation. But like Zeeshan said, and he was giving the example of the fact that if I go in for a mediation, my counterparty would have flooded the market by the time the notice for mediation is given. I wanted to add to that it has happened to me that the counterparty has flooded the market and not refused mediation, which actually forced me to follow the commercial suit where he refused to come in for mediation, saying there is nothing to mediate in this. And he continued the violation, which then I had to take more stringent, aggressive measures to safeguard my client's interest. So the point is that, yes, there is a mechanism available to us, but it is not something that is conducive to the digital environment. Let's put it that way. Not as fast paced, not as aggressive as one would have envisaged. I guess it will take some time to kind of work out the modalities, like having a effective. If you want to integrate the platforms and have them on board, like Aniket very subtly mentioned, that there has to be an efficient joinder of parties available recourse, because you can't go and argue that in court, wait for the court to grant you that permission to join those parties and then follow up, because by that time the boat has sailed. Effectively, the damage that was supposed to be stemmed has already taken place. So yes, contract drafting is not as simple as it was before in the digital age. Copy pasting is a no-no. Apart from people having this notion that contracts are only, what do? You just take an old precedent and you just manufacture, put in new facts, etc. But no, media contracts are a different ball game altogether. Not at the cost of confidentiality, so I will not take names, but I had a media client who, in all fairness and in order to safeguard the interest of the company, decided to share not just a script, but a full-fledged plan of the movie, including the costume and a page by page, what they call the progress of the movie, without having an agreement, without having an NDA agreement, because uh, the actress in question mentioned that, you know, we are on good terms, and, you know, in the interest of time, just share the documents, and I will of course have my legal team see and sign the agreement. First defense in her written statement, she said, I don't have an agreement signed. How am I bound? Well, my advice to my client was, please sign it, don't give it, don't do this, don't do that. But the media industry sometimes functions on the whole precinct of good faith, that, oh, I know this person very well. Well, that may be your personal issue, but professionally, you're not supposed to be doing this. Legally, you're not supposed to be doing this. At the end of it, the entire movie was done by somebody else with another set of producers. The lady had taken the whole script, the entire thing, and we just decided that that's it, we are going to work on something else. So it's because we ultimately, my clients realized that the fault was theirs. We gave it a fight, there was a settlement, there was an issue. That's how we parted ways ultimately at the end of it. But the point is that good faith does not stand you anywhere legally. Ultimately, when you need to take a legal recourse, you need to have an airtight document which can support your interest. And in these days, the digital interest, that's more the problem that is existing today.
Thank you, ma'am. I hope we all make a mental note of this so that we don't let ourselves make the same mistake again. My next question is something which is open to the entire panel. So this question is, what is one practical change that lawyers should immediately make while drafting IP and media contracts in light of AI-generated content and online infringement risks? Who would like to answer this question in the panel? Or maybe we can have somebody start the discussion, and then, you know, the other speakers could add to that.
I'll take a bit at this, because we are already exploring something on these lines. And like I said, that most of these LLM is the recent trending term in the AI industry, right? So you have LLM, you have agentic AI, etc. So what's happening at the moment is, of course, there are no laws to govern, right? So it's more or less working in terms of the mutual understanding, how you define what AI means to you, and AI means differently to different people. And another aspect that we need to keep into mind is that, I mean, which all the panelists have already highlighted, is that who owns it? Because it's like a churning. How does an LLM work? We have to understand that. It's like a mixer. Everybody's putting their information. It is, you know, spinning it and then giving out a third information based on what 10 other people would have fed that particular system. It pretty much works on the psychophancy of the algorithm, how the developers would call it, saying that, you know, these LLMs are created in a way to please the user. So it is never going to give you a wrong answer. It is always going to give you an answer which makes sense to you in the way that, you know, what you're asking, you should definitely move in that direction. So that is also another aspect, because it's almost like you're giving a service and you want to please the customer. So of course there are prompt engineering no matter what, but these are some of the aspects of the LLM that we try and consider from the vendor side, from the customer side, who's, you know, who are the two types of parties involved in this. And what is happening recently is the fact that, let's say if I'm a vendor and I'm going to send my license agreement to a customer, the customer comes back and says, either they put a no AI clause in the agreement, they say no usage of AI, which we will push back and say, because the software has AI, we can't really put this clause in the agreement. Versus then they will come back and say, oh, you have AI, so let's say these are the guidelines on which you're going to use AI in your software when you are delivering the service to us. So these are some sort of practices that everyone is trying to regulate in their own way, while understanding how AI works, right? So that is one of the very important part. Technological people, UX developers, product developers do understand how it works. The people like us, lawyers, business people, marketing people who are going and actually pitching the entire mechanism to business buyers, they don't completely understand it. So these are some of the mechanism. So what is happening now is every company is trying to define artificial intelligence clause in their agreement, saying that this is what AI means to us. Then they go and tell the other party and say that, what does it mean to you? Do we create a consolidated clause around it? Or do we create again two different, this is your AI, this is my AI, etc. And how is it really interacting and what is it adding to the purpose of this entire transaction? So you put all of that. And then you also, let's say most of the companies will have their own encrypted LLM created, which is not like an open source, but it is created for internal consumption. So there, the ownership right is very clear, saying that, let's say Schrödinger is giving this AI platform to the customer. This always belongs to Schrödinger. But there are companies which works on an open BIM model. What does that mean? It means 4 or 5 software players are going to come together, put their softwares together, and let the user decide how they are going to create that entire combination of the service for them. This is something that real estate industry works. Very similar to the case that I explained. So more or less, it's about the fact that at what level we are in terms of understanding AI, how does it interact with the service or the product that we are offering? What does it mean to us? Can we segregate it? Can we not segregate it? Can we clearly say that this is open source or this is closed source? And this is the type of input that you're going to get. And one of the examples that I cited in the beginning, that if you are relying on these LLM created agentic chatbots, the complete responsibility is on you. And there's a very smart way to do it. You put it in the fine prints of the TNCs. It's almost like a take it or leave it basis sort of a platform that most of these open platforms have created, right? You go to ChatGPT, you go to Claude, you put certain prompt and a result is created out of this. Of course, people can say that this is assistive AI work, etc., assisted copyright work. But the point is that most of these organizations are mitigating their liabilities at the fine prints. They mention whatever input that you're putting, whatever personal data putting here, it all belongs to you, but we are making a complete disclosure that this is going to be used for marketing purposes. This is going to be used for our, information processing purposes, which will be given to other users. That is also there. Third, if you are taking any decision based on the output generated by our platform, you are completely responsible for it. So if there is a case on these situations, and the user brings it and says, similar to what OpenText is already, it's their line of argument, saying that we were very clear when we give the TNC that this is what it is and this is what you're getting into. If you still went ahead and did it, it is your responsibility. But the point of debate that comes is that, can you really do like a fine print? Do you make sure that the user has enough opportunity to read? It doesn't really work like that. It's almost like you want to use it, you use it. You don't want to use it, please go ahead and find another platform that works according to you. So these are some of the aspects where we try and determine how it goes in the commercial agreements. Depends which side of the service bargain you are at, what sort of liabilities you want to mitigate. If I am a product based and open text sort of a company, I would always want to mitigate how the user kind of responds and interacts with the output generated out of it, and what sort of delusion the user has versus what sort of delusion my platform is creating. And if I am on the user side, I would want to read the fine prints. I would want to understand what am I getting into, and then make an informed decision. Does it really help me, in terms of looking at the outcome that I want? So this is my take on it, and I leave the floor open for others.
If any of the other speakers want to add to what ma'am said, please go ahead.
I'll take a go. So as Ms. Sharma suggested, that who actually owns the AI output, that is one of the larger questions that's still at large today. That debate is ongoing, whether it's the author of the data that was used to train the model, whether it is the engineers who wrote the code for the model, whether it's the investors who gave them the money to do so, or whether it's the company that actually owns and operates the AI platform. So that question courts don't have an answer today, and most likely not going to have an answer in the coming year.
That can be answered actually. So I'll give you an example. Um, let's say we have around 1,000 employees who are working on coding. There are people who are working on the idea and the innovation aspect of it, and there are investors who are putting money into all of this. So now the question of ownership, how you really structurize your IP assignments makes a difference, in the sense that whenever a company is making a proposal, we have to understand the fact that these ideas, whether it is created at a company level, will always belong to the company, right? So now the companies most of the time find a way to ensure that these IPs, no matter they go throughout the entire cycle, they come back to the company, right? So when they are making a disclosure to the investors, they make sure that, my patents are filed, my copyrights are filed, my IPs are protected in this. This is the kind of caution that you give to the investor. Now, when you are, hiring people externally or your employees who are doing the job, when you're hiring contractors, you tell them this works for hire and you get the IP back to yourself. You say that once you have created, you receive the fee and then you attribute the IP back to me. And when you have employees, you try and mitigate at the employment agreement level. So you put certain clauses in the employment agreement and you say, whatever work or IP that you create during the entire employment, 5 years, 4 years, it will always be assigned back to the company, right? So then the employees also gives back to you. Now, let's say it's a collab between you and another customer. The MSA would determine who owns it. Let's say we said that the customer is going to own it. After the whole process is done, the entire IP will be assigned to the customer. Now, let's say if we say that no, it has to continue with the GCC or it has to continue with the parent entity, it stays with the parent entity. So that's how you try and carve out and you say the ultimate owner is going to be XYZ. So if your agreements are crafted well, you can always go back to the origin point of the IP and say that, this is the owner. Rest of them have assigned it back to me. These are the assignment papers. And different jurisdictions have different way of filing these assignment documents. In India, you require a power of attorney as well, right? So, and you have to, even if, and let's say Indian contributor drew a line, they are considered an inventor. So for that, you have to do the whole POA, and then you have to file the inventorship patent, etc. Then it comes back to the company. The company will sign an assignment agreement with the employee. The employee will say, I'm giving it at, let's say, 1 rupee, 4 rupee, 5 rupee nominal amount back to the company, because this is what my employment agreement required me to. Now, this India company is going to do another sub-license assignment agreement with the parent entity. So this is how the whole chain goes. And if it goes to dispute, if you have the agreements recorded, you can always place it on record and say that this is what it is, this is how it is.
Of course, the allocation of who ultimately owns the intellectual property, that is crucial and indispensable actually. I just feel that's more appropriate for traditional forms of intellectual property and transactions relating to that. And the context is essentially where you have a transaction, say, with an AI platform. So we have seen cases, the American case, the New York Times has initiated a case against ChatGPT because they feel that the articles were used in an unauthorized manner. And in fact, a lot of ChatGPT's output has quoted verbatim various articles from the New York Times. In these situations, I feel that what contracts can have is a shift towards more robust record keeping obligations, I would say, provenance obligations, because if they are able to show what was the training data that was used, whether that training data was ever stored in the system or not, or whether they just simply set parameters that resulted in creation of output, who actually prompted or reviewed the output. So answers to those questions can come easily if there are audit trails, there are preservation obligations and timestamp records, so that pinpointing becomes easy. And record keeping, it's still an enforceable obligation today, uh, even when debates about authorship are still going on before the court. So that's the practical change I would suggest should happen to contracts today. especially where AI is
For
involved.
example, if New York Times and ChatGPT don't have an agreement, then it is a dispute, right? So it's not really an agreement, but it more or less becomes like an ethical IP issue. Can you do it? Can you not do it? So
Yeah,
yeah.
it's an infringement claim.
So, in fact, to add to what Nishtha has said, you all would have heard about the Stephen Thaler case, which is going on before the Delhi High Court these days, wherein he generated an image out of an AI, and he filed an application before the copyright board wherein he wanted the AI software to be the owner of the copyright. In fact, in his copyright application, the applicant is the software.
Yeah.
And the Indian Copyright Act simply rejected that application only on the premise that the copyright law in India recognizes a human to be an applicant and the copyright owner. So that was the only reason for them to reject this application, and the reason was quite quite evident from the reading of the Copyright Act, because all our statutes probably were drafted and came into effect when AI was not anywhere near. So definitely these acts do not factor and consider these kind of AI generated work. He had in fact gone and filed an appeal before the Delhi High Court, and the Delhi High Court has now remanded the matter back to the Copyright Board with the direction that they should now reconsider the matter and come up with a final verdict within a period of 8 weeks from the date of remand. I believe that time period is getting over by end of this month, wherein the and yes, very interestingly, a similar application filed by him before the USPTO has also
Yes.
been rejected on the very same ground that the software cannot be the applicant. There cannot be a proprietor of a copyright image who is not a human. That was the reason given by the USPTO, and an identical reason given by the Indian Copyright Board as well. The Delhi High Court has remanded the matter back for a fresh consideration to the Copyright Board, and we are all waiting for a final judgment that will probably show some light as to, my first query. On my first query as to if a software generates a work, an image is generated using an AI, who is going to be the owner of that work, whether the software, whether the person who created the software, the engineer, or the ultimate beneficiary of ultimate user of that software. So this is something that is a very interesting area for which probably we do not have any certain answer as of now, but we are all waiting for that Stephen Thaler's copyright application and that remand order back to the copyright office. Let's see how do they react and what is the
But
final outcome of that.
But Zeeshan, to just supplement your proposition, I was equally amused by the Delhi High Court order, in fact, remanding it, because I don't know what other order the Copyright Board can give in this case, because the basic premise of the IPR laws anywhere is that the human is the creator of that particular IPR that is generated, whether it be a copyright, trademark, or a patent, whether it is a software that is created or something like that. But now the point is that if the Copyright Board needs to reconsider it, I my mind is completely puzzled as to what other invention they will do to supplement their yes or no.
My hunch is that they're going to come up with the same order. Even in a reconsideration order, probably the Copyright Board is going to say that as per the Copyright Act, because obviously they have to follow
They
the
have to.
statute.
I mean,
Uh,
the only thing that can happen is a complete overhaul of the IPR laws as they stand. I
Yeah,
mean,
unless there is an amendment,
amendment.
or or the court comes up with some direction. I'm very sure, most probably, the Copyright Board is going to come up with the same order once again, saying that if there is no human applicant involved in the application process, probably they cannot allow a copyright application to be registered in the name of an AI software, and then it'll be back to court. I think this is going to be a landmark decision by the Delhi High Court as to who can be the ultimate beneficiary
Ultimate
and owner of such work. So we'll
Yeah.
all have to wait for this. This is a gray area as of now. In fact, USPTO has also rejected a similar application on the very same ground. So yeah, this is an issue world over. We'll have to wait and watch as to how does it take place.
So the act already defines digital works. Maybe it just needs to define digital authors also.
Authors.
Absolutely. And the reason is when the Copyright Act probably was drafted and enacted, digital authors were not somewhere near it.
Unimaginable.
Yeah.
May I begin with the remaining questions? All right.
Yes,
My
please.
next question is addressed to Ms. Nishtha Sharma. My question is, many technology and media disputes are cross-border in nature. The contracting party may be in India, the platform may be based abroad, and the content may circulate globally. What practical issues arise in choosing the seat, governing law, and enforcement mechanism in such contracts? Over to you, ma'am.
Thank you. So I think it's things have evolved now. Initially, it was definitely a challenge because when we talk about arbitration, or when we are first, you have to make a decision: do you really want like a court's jurisdiction, or do you want an arbitration, right? So that's the first decision that you have to make. So most of the software companies, if I have to put it, or let's say not just software, technology related companies also, the preference initially was to look at court's jurisdiction, because their idea is that if there is a dispute, we would rather take it to our home ground than put it to a new jurisdiction, so to say, where we don't really understand the judges, we don't really understand the judicial system, etc. So that was definitely the preference, one aspect of it. Second was that arbitrator, like I mentioned in the beginning, that the expert arbitration panel was still evolving initially, in the sense you would not have too much of people who were in the IP or who would understand the evolving technology. I mean, we're talking about AI now, but AI has evolved in the last 15 years in bits and pieces. It's not like it's a new thing. It has been evolving slowly. So we did not really have too much of expert arbitrator. So the trust again went back to the court, saying that, you still have the laws, you still have the act, and the judges have worked on those acts and laws and passed judgment. So you would rather go to the judges than to these expert arbitrators, right? But I would say that shift has happened, in the sense that there is more trust to the arbitration side of the business, where more and more evolved expert arbitrators have come into picture. I mean, let's say recent arbitration that one of the customers did, we had GCs, ex-GCs from product companies or ex-GCs from technology companies who are working as arbitrators. So they definitely understand how the entire ecosystem works, because it's very important for you to understand the ecosystem also, not just only focus on what is the bone of contention. So that shift has happened. So now let's say if we are discussing about how do we really define an arbitration clause in our commercial agreements, there are certain factors that we take into consideration. One is, of course, where is our IP, licensed, or what is the origin point of the IP? Let's say for us, it is US. So we would always want the lex arbitrae as well as the governing law to be New York, right? Because you would want the interim protection in New York, in your own home ground, and you would also want to make sure that the agreement is interpreted as per the New York laws, because the New York law understands the IP that you have created, right? So that is one of the factors. And I'm just giving an example from my company, but most of the companies have similar approach. The first level of agreement that we would anytime receive from other party, they would always put their home ground in it. And then the whole discussion around, no, let's make it mutual, let's figure out a neutral venue, and then the whole discussion would come into picture. So what do companies do in those situations? You always have a backup of those governing laws and I would say the seat of arbitration or the venue of arbitration. And these are all three different terms, and all of us understand that, right? So let's say we say, no, New York is not favorable. The customer comes back because the customer is in APAC and they would want to have probably Hong Kong or China, etc. Then we would go back and say that, okay, fine, if New York is not acceptable to you, we would prefer having it in Singapore, because Singapore, out of all these APAC regions, is more evolved in terms of IP first. Second, you would also see what sort of interim injunction and what is the speed of those interim injunctions provided. if at all it goes to Singapore or any other neutral region that the customer is offering. So most of the time, the companies would always have like 4 or 5 backups. If this does not work out, you go to this XYZ and then ultimately settle at a 4th level or a 5th level. So that is another consideration. And interim protection, like I mentioned. The language is also very important. I mean, of course, we try and say that English is going to be the language of the arbitration. But if you have, customers from China, if you have customers from Philippines, they want to have a dual language arbitration. Now, how do we do a dual language arbitration? Because they will do it in Chinese, we will do it in English, and you would always need like a translator from both sides to explain. And that completely stretches the entire process because half of the time we'll spend in translating. So you then, try and put your head and break your head in the way that, no, we want English, we want Chinese, etc., etc. So those sort of considerations also happen. Most of the time, most of the companies have able to kind of negotiate on English because that's something that is well spoken across the globe compared to, a certain language of a country. Then, of course, the time, the cost, and the confidentiality. I mean, these are some of the basic factors because of which arbitration picked up pace over litigation is. Confidentiality in the sense you will look at different disputes. If it's something like a cease and desist sort of a matter, you would also try and see that the time and the cost that you're spending in managing the dispute versus just figuring out an out of court settlement, does that make sense? Where are we spending less time and less cost? Because companies are always moving in terms of their advancements. They wouldn't want to spend too much of time in all of this process. So that cost analysis also goes on, saying that fine, it is going to satiate my ego as a company because I want to make sure everybody knows that this is what my right is, versus I don't want to pay attention too much to it because I have bigger things to look at. So this is how, most of the companies, they have this sort of an attitude. So they allocate the time and the cost. And the first question the leadership would always ask is, how much time is it going to take? So if you say that the dispute management, even if it goes to arbitration, is going to take 6 months because, you will have parties traveling, you will have to manage all the coordinates, no matter how you say it takes time. So then there is a 6 months, no, it's not going to work out because in 6 months, we are going to launch 3 other products, right? So the speed matters to them as well. And at the same time, confidentiality, like how small or big the matter is. If the matter involves a technology which is not yet out in public, it is still proprietary, it is still in the building phase, you would want to have it within closed rooms. You would not want it to go to the court because let's say Zeeshan mentioned that, by the time you get an interim injunction, the other competitors are already out in the market talking about, launching their own subsidiary products. Sometimes it's also about the opportunity cost, right? Because if you're already building, and nowadays we are seeing that all of these companies are competing, who comes out with the technology first? Everybody has that piece of technology, who has a better technology to it, who's launching it fast, right? So in all of those situations, confidentiality also plays an important role because you have promised to your investors. Second, you have made promises to your board and say that this is what my idea is. This is the amount of money that has been put in this particular idea. This is what is going to be the revenue in first year, second year, third year, so to say, right? So these are the reciprocal obligations. If one cycle is missed, your entire promises cycle breaks, right? So you have to really be very mindful, be craftful with all of this. So yeah, I mean, these are some of the ways we try and see. And the shift from moving to litigation to arbitration, we still see that, in most of the regions, I would say when we have a distributor model, or let's say Malaysia, Philippines, where arbitration is still not evolved, we would still prefer to have court's jurisdiction. So we keep moving between court to arbitration, depending on the scenario, depending on the region or the type of customer we are dealing with, or the other side, it can be a vendor also. So yeah.
Thank you, ma'am. With this, we now open the floor to questions from the audience. If there is anybody who would like to ask anything, you can leave your question in the group chat, and I will ask them on your behalf. Because of paucity of time, we would only be able to take 1 or 2 questions. So if there is anyone in the audience who wishes to ask any question from our speakers, you may even raise your hands. Since we don't see any questions from the audience, I would like to proceed with one more question, which I have for Mr. Aniket Aggarwal, after which we will conclude the Q&A. Sir, my question to you is, in insolvency or corporate restructuring situations, IP assets such as trademarks, copyright, software, and media libraries may become commercially important. What kind of disputes can arise around these assets, and is arbitration suitable for resolving such commercial conflicts?
This is one question I had to spend quite some thought in, and unfortunately, I wasn't able to sort of formulate a positive answer that would expand ADR's role in the insolvency context. And what I will say is that the insolvency regime highlights that essentially not all intellectual property behaves in the same way. Certain brands and trademarks, they might have a value and retain value over many years, but something like a software license or a package for media rights, that can lose value very quickly. And two examples that we have from the aviation industry are Jet Airways and Kingfisher. So when Jet Airways was undergoing insolvency, the resolution professional actually attached a sizable value to its trademarks, and it was part of the information memorandum that was given to prospective resolution applicants. And on the opposite end, Kingfisher Airlines, when the information memorandum was prepared, the RP was of the view that the brand had received so much bad publicity and it had deteriorated over the years that it refused to even include it as part of the list of assets of the company. So that sort of highlights the distinction between how IP will behave. And it becomes important because insolvency is often measured in months or years, while commercial value of that intellectual property may deteriorate much faster. Common disputes that I see arising is, the primary dispute is with regard to the valuation of the intellectual property. What value do you attach if it is being included as part of the insolvency framework? And ultimately, royalty claims may be there, and protection and continuation of ongoing licenses is also an important factor. Now, ADR and other expert processes do offer the speed and expertise required for resolving these issues. But unfortunately, the framework of our insolvency code is that those might not be able to come into the picture. And the reason being, the IBC contains a moratorium provision. It bars the continuation of legal proceedings against the corporate debtor, and the resolution professional who is appointed to manage the affairs of the corporate debtor has sufficient powers to avoid transactions which it feels are undervalued or preferential. And there are other categories of avoidable transaction also. And ultimately, if the debtor undergoes liquidation, then RP has the power to terminate and disclaim onerous contractual arrangements altogether. So the current statutory framework of the IBC does not really provide much space for ADR to act as a suitable avenue for resolving IP-related conflicts. That is my view, and that I feel is a significant gap, and some legislative intervention may be necessary to provide room for these alternate processes to uh, create some resolution for IP-related conflicts in the insolvency context.
So thank you, sir, for answering this question. Now, with this, this brings an end to our Q&A segment. Thank you to all the speakers for such an enriching and insightful session. This discussion truly brought out the complexity of the disputes that arise in this sector, in the IP and media sector, and how the various dispute resolution clauses in this sector cannot be treated as boilerplate clauses. The various nuances of using ADR for solving these disputes, they were all talked about in great depth in this session. So a big thanks to all the four speakers for such an enriching session. And thank you, IIDRC, for organizing such a timely session on this topic. Thank you to everybody, all the participants who joined us on a Saturday evening for this. I now hand over. We've got one question from the audience. If somebody could quickly answer this question, I would like to take this up. Or maybe we can, okay, we can, like, if any speaker could briefly answer this question, it would be great. And if at all, let's say the audience member wants to a more detailed answer, they can probably contact you after the session, I believe. Would that be okay?
To briefly answer this, I think the question is, what if someone has a .in domain name and a competitor starts using a .com domain name? So there have been a lot of judgments which says that CCTLD does not matter. It is the main mark, which is the dominating factor of a domain name, apart from the CCTLD .com, .in, .cin, .us, .au. While considering an infringement or a domain name dispute, you do not have to consider the tribunal usually do not consider the CCTLD. What the tribunal considers is the main part, the dominating factor of the domain name. So if, let's say, someone has been using airtel.in, and the company has been using airtel.in, and there is someone who starts using airtel.com, so CCTLD does not matter. It's the main trademark, which is the important factor and which has to be considered by the arbitral tribunal while deciding a domain name dispute. So .com, .in are ancillary factors. They are not important at the time of deciding a domain name dispute.
Thank you so much for answering this, Zeeshan sir. Back to thanking all the speakers for this wonderful, wonderful session, where you spoke about so many things on the subject matter in great detail. And thank you to all the participants for joining us. I hope the discussion was both insightful as well as useful, leaving with a lot of thought-provoking matter that most of us would like to dig in and read up on further. So I would now like to request Adri from IIDRC to proceed with the closing remarks.
Sure.
Thank you, everybody, for joining.
Thank you, ma'am. So
Thank
before
you, Dr. Lahoti. It was, in fact, a very interactive session with your inputs. Thank you so much.
Yes,
Thank
sir.
you, Dr. Lahoti. In fact, for this insightful conversation from all sectors. In fact, what I found it most interesting was having Ms. Sharma across, also giving the industry point of view, not just us lawyers putting our two bits to the entire dispute issue.
Thank you, ma'am.
Thank you, ma'am. Thank you. So before we conclude, I would like to extend our sincere appreciation to our moderator and distinguished panelists for drawing on their vast experience to share such valuable perspectives. Your collective expertise and IP and media arbitration greatly enriched this session and made it both insightful and impactful. We also thank our all participants for being an active part of today's discussion and for contributing to this knowledge training initiative. E-certificates will be provided to all the registered attendees in 2 to 5 working days. We look forward to welcoming you for our next session in the AAI series to be held on 4th of July 2026 on ADR in cross-border trade. In this case of any inquiry, any query, you may reach out to us